was also not listed yesterday. The order sheet is with this
Which one?
steno.
Give the number, we'll check it out.
Yes.
My lord,
May I beg your pardon?
the bail matter, my petition is since 9 months in jail custody.
Tied up, bail matter. Bail matter.
Three number of bail.
Yes.
Item
May
number
I beg your
5.
pardon, Lordship?
We'll go page wise. We'll
Yes.
go page wise.
May I beg to pardon your Lordship?
Yes, madam.
My lord, item 23, my lord, kindly
1 minute.
listed two.
Page wise. Page wise I'll call. That will be easier.
Yes.
Okay, yes.
Mention item 1 to 5.
Item 5, my lord, this matter has been, this is a matrimonial dispute, arose out of a matrimonial dispute. This was referred to the mediation center. Then mediation center has fixed the next date to 24th.
After 24. Mediation report is awaited. Please the matter so and so interim order to continue.
May I please, Doctor? No, sir, item number 1, my then senior is present. Sir, Agarwal is present. Don't call it some other way.
Okay. So, on the request of Mr. Patnaik. One.
The Lordship may record man.
Yes, his presence also, huh? Mr. Agarwal's presence.
Item 6 to
Mr.
16.
Mr. Agarwal with dark glasses. Presence. Yes.
Item 6 to 16. Item 17 to 24.
Item 17, kindly on behalf of Katya.
17.
Yes, my lord.
What do you want?
Any other day, my lord.
On request. but-
May I beg pardon, Lordship? My lord, 23 item, my lord.
Yes.
My lord, 23. My lord, tomorrow may be listed, your Lordship.
Huh?
Tomorrow, my lord.
No. If you want to argue, otherwise it will come at your own.
Obliged.
Adjourn on request adjourn. We mark
Obliged, your Lordship.
end. You are asking for adjournment or March? Yes.
25 to 31. 32 to 39. 40 to 46.
I beg your pardon, your lordship. Item 40 on behalf of Mr. D. Naik, senior counsel.
41.
will be adjourned. 40.
40. Okay. What do you want?
Adjournment, your lordship. on behalf of Mr. D. Naik.
Item 45 and 54 only.
45 and
54. Honest, counsel for the petition is absent. If I'm not there, it will be bad.
you
And
just
I-
intimate. Okay. Adjourn on the request of 45 and
54.
54.
My lord, item number 53.
47 to 53.
My lord, item number 53. Kindly adjourn me on behalf of Mr.
Okay. Request adjourn.
55 to 60.
And that's item 60. So, hearing mathematics may be tagged in the weekly Monday list.
Okay. Weekly list. Top. Why it has come?
That's for hearing only, under the heading of hearing only.
Hearing not possible to other. Yes.
Great.
Item 2.
Yes. Item 2. Nobody is there. Pass over.
Item 3.
Please, your lordship. Okay, I am
Yes.
there. Actually. Lords, here the petitioner is aggrieved by an order of the learned sessions judge, Special Judge Vigilance Dhenkanal, dated 23/7/2024, refusing to discharge him from the trial. The impugned order is at page 15 of the brief. May I draw your lordship's attention to page 20, my lords.
Okay. 20. Yes.
If your lordship will look at the last paragraph of page 20, the court
Yes.
writes like this. On perusal of record as well as the connected documents, it is found that a trap was laid on 9/11/2020, during which accused Bipin Bihari was caught red-handed in the portico area of DRDA office, Dhenkanal, while demanding and accepting bribe money of rupees 16,000 from complainant Jagmohan Panda through one Shakti Prasad Mahanti, civil contractor, and as per direction of accused Das, complainant Panda delivered the bribe money to Shakti Prasad Mahanti and it was recovered from the left side back pocket of the wearing full pant of accused Shakti and seized at the spot in presence of witnesses. Now,
Yes.
your lordship may look at the next page, my lords. If your lordship will look at in the middle portion, my lords, there is
Yes.
a letter number 3995 dated 1/12/2020.
Yes.
It says, admittedly under letter number such and such dated 1/12/2020, it is replied by the DRDA Dhenkanal that present accused Bipin has no role in connection with execution of LED light in Dhenkanal district. Similarly, under letter number 622, DRDA has also stated that no order was issued from the office in the name of Bipin to assist Ajay Kumar Jenna, the then executive engineer DRDA Dhenkanal. However, at a later stage, under letter number 555 dated 25/10/21, IO asked for clarification regarding role of the accused JE DRDA in process of release of final bill under the said work regarding LED light, wherein the reply was suggested that there is no role of Bipin Bihari Das in the process starting from tender to release of final bill. But against a comprehensive query submitted by the Inspector Vigilance, it is specifically reported that accused was allowed to supervise construction work undertaken in DRDA Dhenkanal in addition to his own duty. Now, if all these things are there, my lords, my respectful submission is that the learned special judge was in error in holding that there is a prima facie case. More so, my lords, since at page 20 the court says accused Bipin was caught red-handed in the portico area of DRD office Dhenkanal while demanding and accepting bribe money. Now, I will ask your lordship to kindly look at the page number 29 of the brief. That is the preparation report.
Yes.
Your lordship may kindly see what he writes in the last part of the first paragraph. As he is going to give the bribe amount of 16,000 to Bipin Das AE against his will as per his demand on 9/11/2020, he reported the matter to the SP Vigilance Cutter. Has your lordship got?
Yes, I got.
Now, this was the preparation report. Now, your lordship may kindly look at the detection report, page 33, my lords.
33.
Yes.
Yes.
33, he writes, second line I am placing. As per the plan, the vigilance trap party reached DRDA office Dhenkanal at 10:30 am. Vehicle was parked 50 meters away from DRDA office Dhenkanal. Complainant Panda and overhearing witness Acharya proceeded to DRDA office Dhenkanal, where Bipin Das AE was found standing in front of the DRDA office. Panda
That is the portico. That is the portico.
yeah.
Yes.
Panda complainant discussed with him, requested him to pass the bill, but he told him to come to his office after 2 p.m. Hence, we all, along with the complainant, returned back to the unit office. Then, my lords may see the next paragraph. After 2 p.m., complainant overhearing witness Acharya proceeded to the office. Rest of the party were waiting at reasonable distance and awaited the signal. Complainant and overhearing witness Acharya went into the office room of Bipin Das, AE in DRDA office, where he was present. At about 3:35 p.m. on receipt of prearranged signal from overhearing witness Acharya, the rest of the trap party members immediately
So this has happened inside the office room.
yeah. Said, rushed to the spot, found the complainant Ponda was standing in front of the DRDA office, that is the portico area. Lords, how can this happen? ऑफिस रूम भितर को दीटा बेलू पशिले सिग्नल है आज्ञा ऑफिस रूम रु ये आइला बेलू पटिकर मु छिड़ाई Is it not a contradiction in terms, my lords?
Yes.
And he
Yes.
says, two persons were standing close to complainant Panda. Panda identified one as Bipin Das, one Sri Sakti Mahanti, and before few minutes, he has given 16,000 to Sakti Prasad Mahanti as per the direction of Bipin Das. Now, if this is the detection report, how does the court, my lords, write that I was caught red-handed when I was accepting the bribe?
Good. Yes.
Lordship can receive the page 33.
33
3.
years. And there.
79%. Para 3.
Yes.
Initially, he made the petition. He told that come at 2 p.m. Then at 2 p.m. Thereafter he went and went to his office. Over in witness stands in the veranda of the office. Then he directed to give the money to a person who is standing in the portico. That is the third person who has accepted the money. Then this petitioner came out and identified that money, that person. And under his direction, the money was.
Where is that? Where is that part? Where is that part?
Then
He came out and
that is, two persons were standing very close to the complainant, say third paragraph. The complainant over in witness Santosh Kumar Acharya went into the office room of Bipin Das at about 3:30 p.m. Next line. Two persons were standing, your lordship got it.
Yes, I got it.
Standing very close to the complainant Sri Panda. Complainant Sri Panda identified them as one Bipin Das, assistant engineer, the present petitioner, one Sakti Prasad Mahanti. Before few minutes, he has given 16,000 to Sakti Prasad Mahanti as per the direction of the Bipin Das, the petitioner. Then I disclosed my identity. Then being asked, he disclosed his name as Bipin Das, so and so, so and so. And the other person disclosed his name as Sakti Prasad Mahanti, so and so, so and. Today he came to the office of Das for some professional work. Hearing the name of Vigilance Das and Sri Mahanti became nervous and kept mum for some time. Then on confrontation, Sri Das agreed that he has demanded 16,000 from Panda for releasing his pending array bills, and on his direction, Sakti Prasad Man, civil contractor, who came to his office for some professional work, he received the bribe money of 16,000 from Sri Panda, and further he added that he has not touched the money. On course of detection, Sri Sakti Prasad Manti handled the tendered bribe money as per the direction of Bipin Das. Hence, the right hand of finger was came positive. Next part of left hand was positive. Then the pocket was the money was recovered from the pocket of that Mahanti, and it was the pocket was also positive. Then second part. Next page. After demand and accused Bipin Das, he has given the tendered money of 16,000 to one Sakti Prasad Mahanti as per direction of Bipin Das. Then last para. On being asked, the complainant Jagan Mohan Panda stated that he, along with the overhead witness Santosh Kumar Acharya, proceeded to DRD office Dhenkanal at 10:30. When they reached in the office of Bipin Das, he was found standing in front of the DRD office. He discussed with the Das and he requested him to pass the pending array bill, but he told him to come at office to pay. Today, 9/11/20, as he was busy now for some other officer. Hence, along with the overhead witness, returned back to the unit office, Dhenkanal Kanto. Thereafter, 2 p.m. again, along with the overhead witness, vigilance office proceeded DRD office. He and overhead witness Santosh Kumar Acharya entered into the office of DRD Dhenkanal. The other official or the other vigilance officials were waiting at the reasonable distance on the outer so. He entered into the office of the Das J, and the overhead witness Santosh Kumar Acharya waited in front of the office room. He discussed about the pending array bill of the Das asked him if he came prepared with the bribe.
As per the direction, Siddhas, and he came outside the office of Siddhas and saw one person standing in front of DRD. After a few minutes, Mr. Das also came out of his office and identified the person's phone. You also came out to the portico and identified.
And section 7 says,
Correlate with what has been stated in the first part. It doesn't correlate with what has been stated in the first part.
These are the contradictions you can
No, it's not a
cross-examine him,
contradiction.
cross-examine.
Lords, my submission is this. If you say that
See, the first question is you are not in charge. Ultimately, on the clarificatory letter, the clarification has come that you have been supervising.
where
This
is that
part is
letter,
there.
Miller? There is no letter on record.
But that is referred to. The letter is not there, then you will be benefited. And second is in the portico it has happened. And in fact, 2 o'clock when they went and you came out and identified Mohanty. That is what it is
Your
reflected.
Lordship will take into consideration one other thing. When
Yes.
has this incident happened? This incident has happened in 2020, Millards, during COVID. How many people will be there outside, Millards? And if, Millards, I am in no way concerned, Millards, where is the question of my accepting a bribe? And if they went inside the office room and the
That this
discussion
is-
was held, how could
But
the
come on.
overhearing witness?
But this is not a case for discharge. You
My
may
submission
get
is
acquitted,
that
but not a case for discharge. You are appearing whom?
Because I am not necessarily-
Oh, you are assisting. Okay, assisting. Okay.
No specific allegations are against him, except for saying that that he had gone. That's the only point, because the department itself says that he was no way connected with the.
No, there is a
The
clarity.
public servant demanding and accepting was that's an
Inquiry, the IBU himself finds out.
It is always not necessary that you are
in charge of.
assigned to the job. You may say that I'll get the work done also.
But why should I demand a bribe?
All
if
these
I am
things,
not
all these
there?
things that
And even in COVID time, who will go and stand in public place, not. This only
Anyway.
shows that no one was there.
Anyway, I'll pass the order. Huh? Yes. Yes. Give it. Hard copy. Okay.
Item 4.
Item 4 is checking for a parcel.
Item 4, my lord, your lordship last occasion wanted to know what is the specific material against the present petitioner.
Yes.
So we'll take just the last chance.
Let come for the state.
2 weeks.
Seek an adjournment to get further instruction. Use the matter after 1 week. Yes.
My lord, oblige.
Item 6.
Release of vehicle. Last occasion, my lord, directed to
Release of?
release of vehicle.
Yes.
Seized under section Odisha and Bihar Excise Act, my lord. And now the constitution.
Yes.
The constitution proceeded already started. Page 10.
Page 10.
Yes. Page 10, para 3.
Yes. Yes. Where is that particulars? I told you to give the particulars of.
I will take insertion.
Mr. Mandran, Extending Council of Political Party is directed to obtain the status of confiscation.
Status, I will obtain. No,
When
not-
I see these matters are unnecessary pending.
Oh, one such matter. Any one
Uh,
such.
the State Council is not able to obtain instruction pursuant to the order dated 10/12/2024 and seeks one more opportunity, release the matter also.
Oblige.
Item 7.
Oblige.
Yes.
Item 8.
May I please, Your Lordship, I am appearing virtual, no, Your Lordship. In the present case, the petitioner challenges the order dated 30/9/2024, Lordship passed by learned ad hoc additional session judge. Lordship, in case there long-standing civil dispute, I've averred the same in page number 5, Your Lordship. So also there is a case and counter case, and admittedly both the parties belong to same family. Lordship, there is every chance of amicable settlement between the parties.
No, POXO is there. What is the POXO?
So is mechanically added, Your Lordship. There is in Annexure 3 is the counter FIR, Your Lordship. So far, the mother of the victim is concerned. She has filed series of cases against the brother of the present petitioner, Lordship.
If you want to settle, settle and come. I will not issue notice. Because this is not a case for discharge.
Apart from that, my lord, POCSO Act, your lordship.
POCSO is there, how can you expect discharge?
Lordship, notice may kindly be issued.
No, I will not issue. There is nothing. How can I issue notice? Simply I'm adjourning. Adjourn. On request, yes.
Item 9.
May I please, your lordship. Lordship, it's a passing of congruence to the ground of compromise, your lordship. Both parties are present, your lordship.
Also, my lord, POCSO Act is there.
POCSO is there, how?
So, my
My lord, they are already, both parties are already married. And
Maybe, but POCSO, the judgment, just see the judgment.
Ramjilal Bora and
Ramjilal.
of Rajasthan and others.
last occasion, lordship was.
You just see the Ramjilal, have you read that judgment?
No, your lordship.
Then you read that judgment first of all. It is not a routine thing now.
My lord has also quashed, but subsequently the government has come and go through that, argue that case.
That comes for the petition. 6 times. Yes. Next.
Item 10. May I please, lordship.
The matter is amicable settled between the parties, my lord. 10 is FIR.
What are the offences?
Offense, my lord, 341,
23 and all.
294, 506 and
Yes,
31,
yes.
my lord. And along with the item 34, my lord.
34.
Case and counter case, my lord.
Case, counter case.
Yes, my lord.
Where are they?
Item 34, my lord.
34, huh?
Yes. Both are in family dispute due to civil. Matter amicable settlement.
34. Yes.
There is page 9 is the affair. Page 9 is the contents of the affair.
Sorry? 34,
Nine.
34, what are the offences? 307, 34. What is the injury?
There was in simple in nature, my lord.
Simple nature.
Simple in nature.
Show me injury.
34.
34.
No, you 455.
4557. Show me the injury report.
Just
34.
First case there is a simple in nature. The page 5, item number 10.
10 I understand, 323.
Simple
34, 307. Tell me the injuries.
My lord, in 10 item, the petitioner is Dilip Khat.
I understand
Yes,
10 is
that-
okay, but 34.
In counter affair, there the
That's
asset.
right, but what are the injury I want to know? 307 is there and
Yes,
on
my
the
lord, my
ground
lord, my
of
lord.
settlement, if you want to get it quashed, at least tell me the injury. Which part of the body?
But is my lord.
You don't prepare and come, that's the whole difficulty. These are minimum thing. 302 is not routine, you settle and do it. Murder case also you settle then.
No, my lord.
Then tell me what are the injury, which part of the body, what are the weapon used. These are minimum questions is expected. At least this much you must read and come. How are you coming to the High Court without preparing this much? Now you will keep on searching. What kind of pass out.
11.
Get the injury report,
My lord, I'm taking
whether
it.
the injury is serious or not. What is
My
the
lord.
weapon you have used? Which part of the body the injury has caused? All these things are minimum thing.
My
In 307 when you see quashing on the ground of settlement. Read it and come.
My lord.
Pass over.
Item 11.
My lord, because of my throat infection, my lord, I can't appear. Your lordship, I am praying. It's a NIA matter, my lord.
Not able to speak. Okay, urgent. Not.
Other matters are there, my lord. The opposite parties are there. That's why I'm.
It's all right, all right. You're not well. It's all right. Yes, urgent, on request. Give shorter date. Yes. Yes.
12.
One password, my lord.
Leave to my lord.
12 o'clock. Huh?
Compromise between.
What are the offences?
Offenses are under section 341,
Magistrate table, yeah.
323, 506, 35.
Okay.
All are compatible.
Okay.
All are students, man. Both.
It's all right, let them come. Okay. Yes.
13.
Here the petitioner filed this application against the rejection of 205 application and on similar footing another co-accused Millard. This record already granted his 205 application Millard. Here Millard ground that present petitioner Millard is a forest officer, BG functionary Millard, and his frequent absence on the subsidy will cause hardship to the public Millard, as well as Millard, his health condition. I have annexed Millard.
What is the offense?
Offense Millard.
Oh, PC Act.
Millard. I am accused in the charge sheet, supplementary charge sheet, Millard. In the main charge sheet, my name was not there. And in 55 times.
Show me who's the exemption.
Yes, in 55 times, Millard, I have already appeared.
What is the stage now?
Out of Millard, 157 witnesses, 57 are examined, Millard. Without fail, Millard, in all occasions, Millard, I appeared, Millard. And another co-accused in similar footing, Millard.
It will be passed over, my lord, Mr. Marana is on the leg.
I'll have a glass, Millard, then.
The similar order will pass.
Yes, Millard, similar order.
Let it pass to whatever.
Similar order, I was in Jaikan.
Let it pass.
Similar order, I was in Jaikan.
And he is a forest officer, DFO.
Yeah.
He is a DFO. As and when required, he will appear.
Okay, you're
As and when DFO, where will he go? The petitioner is agreed by the order dated.
I don't know when required is present.
Yes.
Order dated. Where is the order? Rejection. Order dated 6/11/2024, whereby his application under section 205 CRPC. How many accused are there?
157, my lord.
157 accused.
Yes. Out of 57 are till that, Millard, examined all the, I am appeared, Millard, without fail, all the time, Millard.
No, there are 29 accused.
I'm sorry, accused.
Sir, 29 accused.
29, sorry. I am a charge sheeted witness, I am sorry, Millard. 29. Yes. Yes.
Oh. Exemption from personal appearance has been turned off. There are and counsel for the petitioner submits that there are 157 charge sheeted witnesses named by the prosecution. Out of them, 57 witnesses have already been examined. The petitioner has been diligently appearing before the court on 8th date of hearing. The petitioner is posted as the divisional forest officer at Bhubaneswar. At Bhubaneswar, the trial of the case is proceeding where? Trial is proceeding at before the special judge vigilance Kyonjar. Traveling to since he is officially posted in a sensitive since he is handling a sensitive posting. Traveling to Kyonjar on each date of hearing is getting difficult. Therefore, he moved an application for exemption for personal appearance. Mr. Mishra and counsel for the petitioner further submits that the co-accused Jagdish Mishra, who is similarly situated, had approached this court by filing criminal revision number 702 of 2014. And in his case, this court has passed the order dated 14/8/2024. The relevant part of which reads under para 9 and 10. Para 9 and 10. Petitioner is also relying upon certain medical, what is this prescription?
Yes, my lord. Doctor categorically stated, my lord, don't long area, don't frequently travel, my lord.
Prescription filed in the annexure 3 and submits that the doctor has advised not to travel a long distance.
Not to move a long distance, my lord.
Long distance because of various ailments, On these two grounds, the petitioner is seeking the exemption from the appearance before the court. Mr. Sanjay Das, learned counsel for the vigilance, however, opposed the prayer made by the petitioner inter alia, stating that non-appearance of the accused will further prolong the trial, prolong the trial. To meet the objection raised by Mr. Das, Mr. Mishra submits that as and when the presence of the petitioner is required, he would be present in the court physically, And for the rest of the hearing, where formal witnesses and formal proceedings is taken up by the court below, he will be moving application under section 205 CRPC for exemption for personal appearance. But on each date of hearing, he shall be represented by his counsel.
317 CRPC.
By his counsel, by moving application under section 317 CRPC. With this observation, the petition is partly is allowed. Yes.
14.
Lordship, order of cognizance is under charge of Lordship for the offence under section 490A, 506, 323, and 4 DP of Double Provision Act of Lordship. Lordship, the issue notice, there is a possibility of settlement. Settlement cannot be ruled out, Lordship.
It's just remove that for the time. Your voice is not coming clear. Yes.
Lordship, possibility of settlement cannot be ruled out. Your Lordship may issue notice. This is I am for the father-in-law, Your Lordship.
498.
Your Lordship.
Issue notice. Issue notice.
15.
Your Lordship, interim order.
You move application. We will trial court for adjournment. Yes.
15.
Come 15 blood. May I please, Your Lordship? There is a very limited prayer before Your Lordship. Your Lordship could see the page 43, the order passed in execution proceeding.
43.
Page 43. Order dated 25/11/24. In a maintenance proceeding under 125 CRPC, 10,000 maintenance per month was awarded. The husband, I am for the husband, that is on the regular payment. On the basis of an additional claim, execution proceeding was drawn up, and Your Lordship would see the directive parts, para 3. Had perused the entire case record, it reveals that the petitioner claimed ₹4,30,000 till 12/9/24 to be realized from the OP, but the OP filed 3 checks amounting to 45,000, which are admitted by the advocate for the petitioner. As such, the petitioner is only entitled to 3,85,000 from the OP. Advocate for the OP also conceded his submission. His prayer is allowed and OP be directed to make payment area dues of 3,85,000 in 5 successive equal installments at the rate of 77,000, commencing for 12 days. In addition to the 10,000 current maintenance.
These are arrears.
Arrears 77,000 is highly excessive because of the fact Your Lordship.
See, this is your counsel conceded. After giving consent, how can you challenge it?
That has been wrongly.
Wrongly, then go and tell that. Oh, go and tell that court.
It is impossible.
No. You have said 3 lakh. You have said total amount. You have agreed that 4,30,000, 45,000.
Yes,
check you have given. Remaining is 385. 385 divided 5, 77. You have considered. What to do?
385 I have considered. I have to pay. But in you also may kindly have a glance, a little glance, as a page 46.
Yes,
Page
yes.
46. Page 46. My
But this is on consent. This is on consent. This pass on consent.
It has been wrongly. My
Wrongly, then move application. I'm giving an.
That has been rejected. Your Lordship may see the.
Okay, you move the application. Okay. Okay.
Yes. 77,000 is my 70,082 is my salary. How can I succeed, concede to pay 87?
Where is your application? Where is your application? Where you have said that wrongly given consent? Where is that application?
No, that is my whole submission. But I have never.
That's right. You have to go to that court and say that the concession given by my lawyer is not correct. That is not my instruction. You have to say that.
Only for modification. That may be.
How can I? Why don't you appreciate? How can I modify in order of some other court?
On my application, that court below may be directed to.
You move application. Then counsel for the petitioner submits that the
I can be
counsel
able to pay 25,000 per month.
Before the trial court has wrongly considered to the order passed by the learned
family court
learned court below.
Family court
2024. He seeks liberty to move appropriate application in that regard. If such application is due, the same shall be considered on its merit. Yes, this point. You move application there. Yes.
Yes. Till then, no courtship action because NBW it is further directed. Next.
What are you asking? You are supposed to go to that court. You go and move application there. Yes.
16.
16 mala applicant is convicted.
Fresh admission.
RI for 2 years. Bail and stay.
Another co-applicant.
Granted in this case, 2 persons have been acquitted. Have been convicted.
Tag with that.
CRLA 1254.
I'll give you the order. Lordship.
Tag with that. Same order.
1254.
Bail and stay over relation 5.
Yes, yes. Bail granted, relation of
fine stay till this way.
Yes.
Like
the copy of the order.
Yes. Mr. Sanjay Das. Yes, next.
18.
What happened? 70?
18.
This is the Belgium matter.
Tell me.
NBW has been issued on
Tell me
dated
the dates. NBW issued when?
13/5/2022.
22. Bail?
Bail was 16/4/2021.
Date you have? 15? Date, give the date when you got the bail.
16/4/2021.
16/4/2021. NBW 13/5/2022. Okay, 500. Yes. 500 each. APA तुम कौन के कोचिंग आज भी तुम कोचिंग करो. Okay.
19.
Finish करो.
19 is arising onto 138 matter also.
Yes.
While the matter is
317 application is a rejected matter and warrant is issued.
APA.
Section 130.
The petitioner is accused in a proceeding initiated by opposite party under section 138. He moved an application under section 317 CRPC, which has been done now by the MP in order and NBW has been issued.
While the matter is postponed judgment.
Here my only submission is that the day when the judgment, NBW has been issued, it was the date fixed for judgment, and I could not appear because I challenging an order passed by the land and magistrate. I preferred an application before the land and sessions court. On that ground, I have filed an application for adjournment, and that application has been rejected.
Judgment has been pronounced or not?
No. Now the date is the judgment is ready for pronouncement. My only submission is that
you go and appear.
My submission that I will appear, but some time may be given to me because
I'm giving it.
Lordship, I'm outside. On 10th of February, if Lordship, I will appear on.
No. I will not hold up the judgment of the court.
Because I will return.
No question. court has written a judgment, he is waiting for your
No, because I'm
honor
asking that, but I'm
to appear in the court.
2 weeks
He will
time-
pronounce the judgment. No,
2 weeks time may be given. I will appear on
No,
the,
no, it
the
does.
judgment will be delivered.
no, you appear on or before 25th.
25th,
No.
and that.
Court can't wait for
No,
you
my only
to go,
submission is-
go and
as- my only submission is that as I'm outside, my lord, I've returned on 3rd of February.
maybe,
So
but see, how can I hold a particular court? See, there are many implications to that.
They
It is
can
easy
what?
for you.
They do admit, my
For
lord.
a judge who has written the judgment,
Yes,
he has a, there are many things
As I
to
have
be.
difficulty,
I
that
can't,
I'll return on
please.
3rd. On 5th, the lord will fix it, my lord, I will appear.
No. But if that judge is transferred, then by that time, what will happen?
On or before.
How do you
lordship,
know?
On or before. lordship,
So many
not-
things happen, sir. In that side, so many things happens. It is very easy for us to say that do it.
On 25th.
He might have written the judgment waiting for the accused to come.
No, yeah, because I have some difficulty, that I'm making.
Let him pronounce the judgment, I'll say. Let him pronounce the judgment and issue an order.
No, my lord, that.
He can pronounce the judgment.
Pronouncement of the judgment, the appearance of the parties is mandatory, my lord.
I'll say that
I'll appear.
let him pronounce the judgment and issue force the process.
On 25th, lordship, will appear.
Yes.
And till that, that will not, I may be protected.
Yes,
because-
that till that you are there. Till that, yes. Honor. Yes.
Item 20.
May I please, your lordship? My lord, it's a Belgium matter. Petitioners are assailing order dated 18/11/2024 at page 20, your lordship. And
Yes.
There are 4 petitioners. And in my paragraph number 16, the dates are bail order
Date, huh? Date, bill and LBW issued on
18/11/2024.
18/11/24. 500 each.
My lord.
Okay.
21.
Lordship,
21.
in this case, there are five eyewitnesses are there. Yes, ମୁଁ କହିଦଉଛି ଆପଣ out of 18
Custody since
Custody since lordship 21/5/23 ବର୍ଷେ 8 ମାସ ଉପରେ ହେଇଗଲାଣି। That
Yes.
70 years old ମାମୁ ଭଣଜାର।
No, out of 18 charge sheet witnesses, lordship,
Mother,
5
that is
witnesses in exam. ମୁଁ କହିଦଉଛି
Hmm.
London trial court rejected the bail application on the grounds that some of the material witnesses were examined. They had supported the case of the prosecution. The copy of the deposition copy of that not served to me, your lordship.
so many
That is-
deposition copy.
They're not served to me, your
Do you have
lordship.
that
I will
deposition
bring the
copy?
notice of the court. That's
ମୋ ପାଖରେ
ଏଇ ତ ନାହାନ୍ତି ମୁଁ ଆଉ ଦେଖିବି କେମିତି?
Give it next week, huh? Next week, keep it next week.
So the
Let
Lord
counsel
court
for the
already-
state submit, but the material, out of how many witnesses?
Charge sheet witness 18, your lordship.
Out of 18 charge sheeted witness,
As per the impugned order, 7 witnesses have already been
7
examined.
witnesses have already been examined. The counsel for the
Till
petition.
August 2024, your lordship. That may be noted, your lordship.
Adjournment to place on record. The
Till August 2024, 7 witnesses were examined.
testimony of the witnesses already examined.
Yes, we get-
Please the matter.
Till August 7 witnesses were
Yes,
examined.
next.
Officer Janes
May I please, lordship?
Yes.
By lordship, earlier, lordship disposed of the bail application by BLPL number 627 of 2024. Order dated 7/3/2024. Lordship granted liberty to move after examination of material witnesses. In this case, there are no witness to the occurrence. Only material witnesses are that when the wife asked the deceased, what happened to you? The deceased said that petitioner and his brother and another person assaulted him. This is the declaration by the deceased before the wife in presence of the father.
Custody since?
My lord. 20 May 2023.
Yes. Yes.
Lordship, what? Now, my lord, the 3 important witnesses, lordship, may kindly see charge sheet. Charge sheet page, my lord, 29. Lordship, got it, my lord.
Page
29.
29, yes.
Yes. Towards, my lord, the first para towards last 6-4 lines. Sarita, complainant Sarita, statement started, my lord. Complainant Sarita Devi. Lordship, got it?
You are reading the middle of the 29 page.
Just last, towards last.
Yes.
Complainant Sarita Devi, witnesses namely Pramila Devi, Amit Paswan has been recorded under 164 CRP statement. Last you got it? My lord, they in presence of them, the deceased said that the petitioner and his brother and other persons assaulted him. when the deceased was
Then
left.
come Sarita,
Yes.
Pramila, and Amit Paswan.
Amit person. Now my
Their
lord, your
statement has been recorded.
yes, your lordship, I can see.
Hmm.
Now, the next part. Now, your lordship directed to move after examination of material witnesses, and these witnesses have already been examined.
3 witnesses.
Yes.
Show me their evidence.
My lord, yes, my lord. My lord, the first is the wife before whom the deceased declared that the petition.
That is Sarita.
Yes, Sarita. Sarita is my lord P3.
Where is that full statement?
P3, your lordship, my lord. I have given.
PW3, yes.
Yes, lordship.
PW3. Yes.
I am the complainant of this case. I do not know the accused person standing in the dock. I do not know the accused Birendra Yadav produced through VC. Name suggested the deceased is my husband. I have not lodged the affair in the police station. He did declared he is not supported.
The wife of the deceased.
Wife of the deceased.
Oh.
And the next is the Ramachandra Pasan, the father-in-law. He is also he does not know my nephew, and he is suffering from illness.
PW?
PW, my lord, 5. He stated that
5 you have not given.
I have given last.
5 you have
Yes.
given. Yes, 5 you. Yes.
My nephew was suffering from illness, and after getting such information, I came to my house. Parak 2. On 17, I was in my workplace at Kantipalli. I received a telephonic call from my wife that my nephew was suffering illness, and after getting such information, I kept to home and took him to DSS Arsogoda treatment, where doctor declared him dead. My nephew died due to sunstroke. And he was driving the vehicle of accused Birendra Yadav, brother of the petitioner.
Nephew is the deceased.
Nephew is the deceased. But they are not supporting.
Yes. Wife and the uncle of the deceased.
Yes.
Yes.
In this case, the 5 material witnesses are there, your lordship. Here, the wife Sarita Devi is, though he has not supported the case of the prosecution, but Amit, who is the son of the deceased, has clearly made out the prima facie case.
PW?
2, your lordship. Kindly glance for a moment, your lordship.
Yes.
Is because he is a minor.
Child
therefore,
witness.
The wife asked the deceased what happened to him. The husband stated the wife that so and so assaulted.
Let us see.
Yes, sir. The informant is my mother. May I read your option?
My mother, and this is.
That is Paswan is my father. I know the accused persons named Deepak Jadhav, Birendra Jadhav, and Ashish here is the Birendra Jadhav is the accused person lordship in this typical lordship. The occurrence took place on 17/5/2023. On that day at about 12:30 p.m. The accused persons Ashish and Deepak came to our home by a motorcycle with my father and left my father in front of our house. My father was not able to move, for which my mother requested the above accused person to leave my father inside our house, and thereafter the accused person left my father inside our house and went away. Thereafter, on being asked by my mother and grandmother, my father told them that accused persons, namely Birendra and Deepak, had assaulted my father.
Then on being asked by the mother and the grandmother, mother herself says that no.
And that I come to that. I was also present in our home at that time when my father told that accused person, the father Deepak and Birendra had assaulted him. This is voluntary disclosure.
No dispute that. Because on being asked.
Let me finish.
Support I don't dispute that.
Documents there, I will place before the court.
Yes.
Therefore, my mother told me.
I proceeded to the house.
Birendra to our home. I proceeded to the house of the accused Birendra and asked about the reason.
Who is PW1?
PW1 is the PW1.
Sarita Devi.
Yes, sir. And another one aspect, your lordship,
1 minute, Sarita Devi. The house of my house is situated in front of Then PW1 is the only source you have.
Lordship, another aspect, your lordship. 5 material witnesses are there. 4 has been examined. And another 5 material witnesses, namely Dinesh Paswan, not been examined, your lordship.
Dinesh
Paswan.
No, his 164 statement was
Yes.
recorded?
Recorded.
No.
Yes.
So,
No, 161, Lordship, 161.
164, three persons were recorded.
164.
All the three persons have been examined. Child witnesses supported partly to you, partly the prosecution case.
Yes, Your Lordship.
The two major witnesses have resigned out of
That's right, that
the.
is
Then
there.
at least he is entitled to bail.
Well, I am in custody more than about 2 years, my lord.
About 2 years.
But voluntarily, the deceased father, before the father and the child they disclosed that present petition and the
chance of conviction is
zero.
by means of iron rod.
Before the deceased was brought by this accused person to his house, and wife was there.
Yes, sir.
And now wife says that
But
he not supporting.
he is not supporting. But only the child witness, he says that when my mother and grandmother asked my father,
Yes.
and he said,
Yes.
but the mother herself is not supporting.
Not supporting.
Lordship, that
Very
one-
chance.
the wife of the
Chance of
deceased.
consent.
Wait. He's entitled to, a murder case. Yes.
Yes, sir, I don't.
The wife of the deceased in 164 clearly stated that involvement present accused person, Lordship. And your Lordship, child also, though.
Yes. And Amit also.
Amit, yeah, Lordship.
And this is the Sarita Devi.
Sarita Devi, but
Sarita Devi,
tech line not supported the case of the prosecution, but
God hostile.
child who has clearly supported the case of the prosecution. That is your Lordship consideration.
Child is the only thing.
Yes, sir.
Child also says that my mother asked.
And voluntarily
And,
his father also disclosed.
It is now.
Already in custody or since 20-5-2023.
Right.
About
It is
2 years.
accused on 81st it is accused in FIR number 74. Allegation against the during investigation, the investigation, the statement of three vital witnesses were recorded under statement of three vital witnesses, namely Sarita Devi, namely
Sarita Devi, Pramila, or Amit?
Sarita Devi, Pramila, and Amit.
Yes, sir. 3-164 statement recorded.
Section 164 here. Pramila is the wife of the deceased. Whereas
Sarita is the wife of the deceased. Yes, sir. Sarita.
Sarita, na? Oh, wife of the Amit is the minor daughter of the deceased. These three witnesses, apart from the others, have already been examined by the prosecution. PW3, Sarita Devi, the wife of the deceased, has been examined as PW3, who in her statement has inter alia stated as under. PW3 means paragraph 1 and 2. Paragraph 1 and 2. The said witnesses has resigned from his earlier statement made under section 164 CRPC and did not support the prosecution. The other witness, namely Pramila, Sarita.
Pramila Devi, PW4.
PW4. Other witness, Pramila Devi, who is examined as PW4, has also not supported the prosecution case. Relevant would be to reproduce a part of her statement, para 1 and 2. Para 1. It is only the child witness, that is PW2, Amit Paswan, who has partly supported the prosecution case. He in his statement has inter alia stated as under para 1, 2, and 3. It is apparent from the testimony of the child witness, that is PW2, that he is not the eyewitness to the occurrence, but he has heard while his mother was asking the accused persons as to how his father sustained injury. He stated that when his mother asked the accused persons as to how his father's is sustained injury, they have stated that they have assaulted themselves. They have assaulted. However, in the contrary, his own mother, who has been examined as BW 3, has resigned out of her own statement. Therefore, for the prosecution, except the statement of the minor witness, who is partly supported the case, all other material witnesses have resigned from their earlier stand. Next, petitioner is in custody since about 2 years. Since about 2 years. Not 2 years.
So May 2023.
Since 20th May 2023. How many witnesses are there total?
37.
There are 37 charge sheeted witnesses to be examined by the prosecution. Out of them, only 5 witnesses have been examined till date. The trial is likely to take considerable time. Hence, regard being head to the nature of evidence which has gone on record as of today, I am inclined to enlarge the petitioner on bail, subject to the petitioner appearing on each date of hearing before the court below without fail. Without fail, and other conditions to be imposed by the court below, and all other conditions. Yes.
Okay.
Yes.
That matter which was there before your lordship.
Yes.
Lordship was pleased to direct the State Council to get instruction as to whether any other materials are available except the co-accused statement as against the petitioner.
Yes.
Yes, Your Worship. As per my instruction, Worship, the other only the confession statement, the main accused who is controlled in the spot, is stated the name of present petitioner others, and present petitioner having no fear. That's for my instruction, Worship. As per direct statement in the last reason, and there is no other material, Worship.
Then.
Yes, sir.
37 bar will not offer.
No, exclusive person is not there, but at the trading time, the present prisoner fled away from the spot, and after issuing an imbue, the present prisoner arrested and is in custody.
Custody from?
The 13/8, 13/8/2024 by virtue of imbue, prisoner was arrested.
Petitioner is accused in so case. Allegation in the petitioner shown. Who is the main accused?
Main accused is Robin.
Who has disclosed?
That is page 19 of your lordship.
Kanu, and who all are who was apprehended from the spot?
And Digal, Amit Digal.
Who accused Kanu Charan?
Anupa Digal.
Digal.
Anupa.
Kanu Digal and Anup Digal.
Yes.
Anup Digal were apprehended from the spot, and what is recovery is?
Recovery
420 kg ganja,
420 kg of ganja is recovered from their position. It is alleged that the present petitioner was although present, but when the police chased, there is no evidence that you have seen anyone. Everybody has seen that.
No, you're not saying. There is no matter.
The petitioner has fled away from the spot. The co-accused Kanu
Charan
Kahar
and Anupa Digal
appears to have disclosed the name of the present petitioner. Subsequent thereto, a warrant has been issued against the petitioner, and he was apprehended on 13/8/2024. The Lieutenant Counsel for the state notice was issued to the State Council to obtain instruction as regarding instruction as to whether except the disclosure statement of the co-accused person, any other material has been collected by the police during investigation against the petitioner or not. It is categorically stated by the counsel of the state that as against the present petitioner, only the petitioner only the disclosure statement is and the petitioner has been apprehended only on the basis
Strength of
disclosure statement by the co-accused person, except that no other material has come on record. Mr. Jana, counsel for the petitioner submits that in view of the admitted position on record, the bar contained under section 37 of NDPS Act may not operate against him as the against him as the twin condition. Condition is not satisfied with the she further submits that the petitioner has no antecedent.
No. He has antecedent. Only on the basis of the co-accused statement, he was arrested and already released on bail by this honorable court.
Where is that?
That is, your lordship, this is an affidavit, your lordship, kindly go. It is there, I cannot say.
Then you file the application. And on query from the court, Mrs. Jana submits that the petitioner is petitioner is involved in one more case, two more cases, and in both the cases, he has been implicated on the basis of co-accused statement. Co-accused statement. Let the petitioner file an affidavit before this court regarding disclosing the particulars of those cases and the facts relating to those cases. Lease the matter after 1 week. Yes.
Your lordship keeping it to next week.
After 2 weeks. After 1 week.
After 1 week.
Yes. File that affidavit.
Okay.
Yes. Because the second part of 37 operates against you. That's the problem. Otherwise, I was thinking that there is no, so therefore I had to. That's the problem. That's that problem you have to overcome.
Yes. Your lordship, oblige my lord. Kindly fix
But
it.
see, I'm still. You can address that question. The second part of NDPS just see. It says that he shall not involved.
Money in future.
It is future. In future, whether the cases which are already registered, whether those things can be read into it or not, I don't know. You just see if you can get some judgment. Something.
Yes.
Because the statute says shall not.
Shall not. Shall not means it is always.
It is a kind of preventive restriction.
Yes.
Preventive restriction. But you have already done it. Whether those things can be read to 37 bars.
Yes.
Just check it up if you can.
Yes, your lordship, only
Decisions
prayer
are
is.
against the senior, but the decisions are against the seniors.
That's what I just want to see.
Your lordship, may I pray, your lordship, may kindly fix a date.
Date will be fixed, don't worry.
Would you?
Date will be fixed.
Okay.
Yes. Just get some judgment to it. Yes, I'll come. Yes. Prabhujit. And Pranav. Right. At the instance of opposite party number 2, FIR number so came to be registered against the petitioner. Investigation complete. Investigation.
Oh.
That's I am asking. Investigation is complete. Why law student? Why ask that? I am. Do you know investigation complete? Charge sheet has been filed or not?
Charge sheet perhaps not filed.
The investigation in the present case is still going on. At this stage, the parties have settled the dispute and filed the present petition. The petitioners are pursuing their law course in which college they are pursuing the law? University. The allegation against the petitioners are so allegation. All the petitioners are present in the court and being represented by their respective counsel and identified by them. The opposite party number 2 is also present in the court today. Being,
Informant. Other one of the students.
No, Rajesh Kumar Raut, who is the father of the, yes, I know that. Opposite party number 2, the informant in the present case, who is the father of another student, is also present in the court, being represented by his counsel and identified by him and filed the self-attested copy of Aadhaar card to establish their identity. From the ଆପଣ ସ୍ୱଇଚ୍ଛାରେ କରୁଛନ୍ତି ନା ପ୍ରେସରେ କଣ ପ୍ରୋବ୍ଲେମ ଥିଲା? On the query from the court, the informant, opposite party number 2, has stated that the parents of the petitioners have approached him and on the intervention of the well-wisher and the parents of the petitioners, the matter has been settled. Matter has been settled, particularly matter has been settled. The petitioners have filed affidavit dated 7/1/2025 entry stating agent para 2, 3, para 2 and 3, para 2 and 3, para 2 and 3. The opposite party number 2 has also filed affidavit dated today, Ajit Sekhito, 8/1/2000 and entry stating agenda 2, 3, 4, 5. 4, 5 and 6. 4, 5 and 6. Mr. General and Counsel for the State submits that the petitioner, petitioners and the victim in the present case are students, and students, due to misunderstanding, the incident had due to misunderstandings, sudden provocation, the incident has taken place. Now they repent for the mistake they have committed and send an apology to the father of the victim, and have also filed affidavit before this court. Therefore, there is and the allegations are minor in nature, hence there is no legal impediment in quashing the FIR. Regarding head to the submission made by the parties and the fact that the parties have settled the dispute, investigation of the case is still going on, and the petitioners are the young students pursuing their law course. I'm inclined to allow the petition. Moreover, subjecting the petitioner Moreover, in the fact scenario of the present case, subjecting the petitioners to the rigors of the trial would be a futile exercise. Hence, the case of the petitioner is covered by the judgment of the Honorable Supreme Court in Bihari Singh, also BH. Accordingly, hence petition deserves merit and accordingly it is allowed. So and so inquiry is required. I'll impose some kind of penalty to these three people. Minor penalty, not in the form of finance or everything. So I'll modulate. They should mend their way as a student. Yes. What they was the last one.
25.
Petitioner was suffering from cancer. Therefore, my lord has directed to take instruction. Directed the government to take instruction.
25. Yes. Demo. Entry model. Right. Which application is this? IA number?
Well, I have not filed, my lord. That I have not filed.
Now, for entry model, you have filed something.
I have not filed any for entry order. My lord may consider.
Where is the document you have filed?
No, my lord. Last time I have submitted on my submission, my lord called for instruction from the government. Last order, my lord. Last direction.
Achha. See, on the submission of learned counsel for the petitioner, that the petitioner has been suffering from cancer. This court, by order dated 4/12/2024, directed the State Council to seek instruction regarding the same. Mr. Vishwal, the counsel for the state, has handed over the written instruction dated 8/1, which reads as under. He has been sent to ENT. Dr. Saran. Okay. Regard being head to the instruction given by the IIC. Who has given this? Jail authority. Instruction placed on record, and the health condition, prevailing health condition of the petitioner, the oral prayer of the petitioner for grant of interim bail deserves merit. Accordingly, the petitioner is granted interim bail for a period of 8 weeks.
My lord, please.
8 weeks, sir. For a period of 8 weeks. Now from the date of release, court initiation bill. Insofar as the regular bail application, insofar as the prayer of regular bail of the petitioner is concerned, then counsel for the petitioner submits that he would withdraw this petition to renew his bail plea before the trial court after the petitioner surrenders on expiry of the interim bail period. With this liberty, the BLAPL number 10605 of 2024 is disposed of. Disposed of, yes.
26.
Maybe I am in BC, my lord. 20B2C of the NDPS Act, my lord.
Yes. Mr. Vishal, and counsel for the petition submits that he has received the case diary recently, wants to prepare the case, lease the matter after 1 week. Yes.
Twice the time has been granted.
He has received it. Let him. Yes.
My lord.
Yes. Yes, madam.
File comprehensive affidavit. Know how many antecedents that I have filed affidavit.
Yes.
Including the present offense.
Yes.
Earlier occasion on 24/9/2024, my lord had, this honorable court has granted bail. And taking into account the antecedent. On verification, it is found that there is antecedent.
Yes.
So the bail application was rejected.
Yes.
Rejection order is under Annex 2, 23/10/2024. So this present bail application is filed.
What is the recovery here in this case?
Recovery 28 gram.
And what about the other cases?
ଗୋଟିକରେ ତ ବେଲ୍ ହେଇଯାଇଛି।
Bail is something different.
ସେଇ ଅନ୍ୟ ଇଏରେ ବି ସେଇ 28 ଗ୍ରାମ।
You are on bail on those cases.
My lord, ଆମେ ବେଲରେ ଅଛୁ।
Just verify, Mr. Verify. Verify. List up to 1. Let him verify. Yes. Yes. He'll give a date, he'll verify. Yes, next.
Date
28. 28. The same case number. Yesterday, the matter was listed before the withdraw. Yesterday,
Same accused.
Same accused, same offense.
So withdraw, I have filed earlier and your lordship was pleased to. Subsequently, he might have filed, that is why he withdrew the application. Previous came the more petition. In my petition, I have given the number. Same accused, he has filed another application. That is why he might have withdrawn the application. I have no idea.
That is 2924.
1228/24.
What is this 2924 then?
Pardon?
2924.
2924. That is my application. In earlier application, earlier I have filed while granting bail to some other accused persons, your lordship was not inclined to grant me and to move, directed me to move after examination of the material witness. That after examination of material witness, I filed this application and my lord on 29/11/2024 by bearing number this application.
I have granted bail to petitioner number 2 and 3.
2 and 3. And one, this Rajendra Naik, his application was turned down by your lordship on earlier occasion.
Okay.
And bail appeal number 2924. So
Yes.
probably my lord, that petitioner has filed after this application, after renewal of the second application, he might have filed. That is why, knowing the same, he has withdrawn the application.
Okay. 212288. This is 1, 2.
Yes, that is right. That is the mistake he has committed. That is how
that with the one which has been withdrawn is filed subsequently.
Subsequently, that is why we withdrew the application.
Yes.
Normal. Normal, your lordship. In this case, the prosecution, my lord, brief case is that. ठीक है, मैं कोई दूँ छी.
Okay.
अच्छा, मैं कोई दूँ.
Call for it.
हाँ, तो
Let him call for it. He doesn't have that. Call for it after 1 week. Yes. List the present case along with the BLAP.
CDটা আচ্ছা.
Yes. Next.
Sorted, my lord, because the material witness of the exam, I have appended all the deposition copies.
Let him get. Yes.
29.
29. I am for
29 urgent. He is not well.
30.
short date में kindly be.
Yes, short date bail matter. Yes. CD, call for CD. Call for CD, madam.
The deposition copy will be supplied.
You supply. Yes. Yes, next.
Next.
31.
31.
I may please. As for the SR 6A defect, the defect has be complied because the review petition arises from the essay, RSA. Then the parties are the same.
Yes.
So no necessary party. And I have filed one IA for delay, 18 days delay only.
Okay, it's all right.
Yeah.
You tell me the merit. On merit, you tell me. Delay will be 20 days delay control.
Yes. I may pardon, Mr. Senior Counsel, Mr. Ramakant Mahanti may argue with the matter. May kindly next date. If the
Learned counsel for the petitioner seeks an adjournment in this matter on the ground that the senior counsel R.K. Mahanti would be appearing in the matter. Lease the matter after 3 weeks. Yes.
obliged.
32.
Lots of the notice we filed delayed. Late file notice may be accepted.
Notice could not be issued due to late filing.
The requisites were filed belatedly, therefore notice could not be issued. The requisites already filed may be utilized for the purpose of serving opposite party. Lease the matter. Yes.
Another prayer notice, the IA number 1003 of 2024. Interim order may be.
Huh?
Interim order may be continued.
First of all, you don't file the requisites in time, and now you want interim order.
Interim order is there.
Is there? I am not touching anything.
Continue.
It will continue if it is there. I am not saying anything. It will continue. It will continue. If interim order is there, it will continue. Yes.
33.
In this case, I filed an application for that I filed for extension of the date of appearance. On 28/11, your Lordship has pleased to disclose this CRLMC. They are referring to your Lordship judgment and directed the petitioner to appear on or before 25th. Since he was suffering from jaundice, I have under annexure A1. Only a short date, my lord.
Which part?
That para 7 and 8, your Lordship, on 28/11/2024, your Lordship. At this is so and so, sir. Appearing before the law and court law on or before 25/12/2024 and resort to the remedy available under law. Hence, no coercive action shall be taken against the petitioner till 25/12/2024.
This is I have given on the grace.
No. Your Lordship is satisfied. Your Lordship have referred to the judgments of the Supreme Court, Apex Court, as well as your
That's
Lordship.
right. Then I say that you go and appear and get
Yes,
it.
sir. Only a short date. Yeah, only
Why extension? You tell me.
only because he was suffering from jaundice.
Very.
That is under annexure A/2, my lord.
3 by
A/2. Page 11, my lord.
11 of your application.
Yes, my lord.
Where is that?
Diagnosis.
IA number?
IAM number 02 of 2025.
02 of 2025. So, where is that? Where is that application?
IA 02 of 2025.
Which hospital is this?
Annexure A/2.
Page
Fever?
11.
Page 11, my lord.
Only fever.
No, diagnosis, jaundice. Your Lordship, para 3. A short date maybe. Within 2 weeks, he will have. It is nice. Short.
Right now. For the reasons stated in the application, IA number 2 of 25, where is that order?
28/11/2025.
Petitioner, the time for surrendering or appearing before the court by the petitioner is extended up till 20th of January. Okay. Yes.
Until that day, no coercive step.
No coercive. Till then, no coercive. Yes.
Obliged.
It is made clear that no circumstances further extension of time
Of appearance
shall be granted.
Obliged. No.
35.
May it please, my lord. I'm appearing virtually, my lords.
Yes, madam.
My lords, herein, my lords was pleased to pass the order while on 27/8/2024 that since the sole appellant has died, the appeal stands abated, my lords. I filed a petition IA number 3 of 2024 for recall of such order, my lords, because an IA number 6 and IA number 7 of 2019, which is already on record, where the appellant has been substituted, my lords, and the same has been allowed.
So what do you want now?
My lords, since the appeal has been abated, I pray for recall of that order, my lords.
Okay. Which IA is that? 6?
IA 3 of 2024, my lords.
6, huh?
3, my lords.
3. IA number 3.
3 of 2024.
For the reasons stated in the application I number 3, the same is allowed. The order dated
27/8.
28/8/2024.
No, it's-
Everything
Order is 27/8/2024.
28. He is in the,
Typographical error, my lord.
in the prayer you have written 28. It should
No,
be
it's 27.
27/8/2024 is recalled. Leaves the appeal for hearing. Yes.
Great.
Thank you, my lords.
Let a copy of the substitution petition be served on us. Let a copy of the substitution petition be served on. It's already been allowed, my lords.
Yes, my lord. It has been allowed since
Yes.
13 to 2020.
Yes. Yes.
Great.
Your Lordship, item 36 on behalf of Mr. Naik, I'm praying for an adjournment, Your Lordship.
Urgent. Yes. On to question.
37.
My lord, I appearing on behalf of Mr. H.F. Mishra. Oh, kindly adjourn the Mr. Mishra. He is absent due to some.
You have taken interim order 2016
Yes, my lord.
and now you are seeking adjournment. Why?
Senior is suffering from.
Who is your
cold
senior?
Himanshu Sankar Mishra.
2016 you have taken stay, now you are suffering. Then counsel for the petitioner, on behalf of Mr. H.S. Mishra, give your name. So and so appears and submits that Mr. Mishra is suffering from fever, hence he is not attending the court. On that ground, he seeks an adjournment. Leaves the matter. Short date. Yes.
38. Kindly pass over.
That's all.
39.
39, my lord. Your lordship is directed to solve the copy of the 1cc case, my lord. The forest officers and the Tahsildar went to the sawmill. There, my lord, they have demolished, and thereafter investigation he lodged here. Investigation was conducted. Then police found that it is a mistake of facts and submitted the final report. And thereafter, my lord, he has filed a complaint case. The complaint case was dismissed on the ground that sanction is necessary because they are the public officers. They are discharged the public. And thereafter, he has prepared this CRMNC, and your lordship is directed to solve the copy of this petition to the concerned officers who are the accused in this case. And they are now placed several places, my lord, on transfer. So the IO, it is some time, my lord, because he has to ascertain where they are placed.
Okay. The notice on opposite
And
party
some
number
of them
2
have
to 8 could not directed to be served through the IIC Dharamnagar police station could not be effected for various reasons. As
some of the officers have
as
also-
some of the as the officers have been transferred, or some of them have also retired. Mr. Jana and then counsel for the
Let's say there is
state
no intermediate.
submits that to the IIC Dharamnagar police station is doing needful in that regard. Leaves the matter on so interim order continue.
Let's say there is no intermediate.
Already said. Yes. Next. Yes.
41.
Bring for password.
42.
41.
Yes, ma'am.
You are appealing for whom?
I'm for the opposite party. I'm for the petition.
Taking password.
Matter your lordship remember.
Are you opposing password what? Yes.
42.
Yes, sir.
In this case, my lord, your lordship issued notice, my lord. The other side has appeared. The last date I was suggesting, my
Notice was
lord.
issued.
Yes, my lord. They have appeared.
None appeared.
They have appeared.
Okay.
Here, my lord, the order of enhancement is under challenge before my lords. Till date, my lord, the present petitioner is ready and willing to take his wife and son. But the wife and at the behest of her father is not cooperating. During cross-examination, she has categorically stated, no, I have understood that she has rejected so moto. So my restricted submission,
If you are the husband,
my lord,
you are ready to take your wife back. Okay.
all along, ମୁଁ ସେଥିପାଇଁ last date suggest କରିଥିଲି, if your lordship will send it to mediation.
If she comes then only.
ଆଜ୍ଞା, ସେ ଆସୁନାହାନ୍ତି, appear କରିଛନ୍ତି, ଆସୁନାହାନ୍ତି.
But what is the problem if you give enhancement? What is the enhancement? How much it is enhanced?
My lord, when I am ready to take my family and my.
So if you are ready to take your family, why are you not ready to pay little more?
My lord, little more. But if somebody has rejected so much, in view of your lordship knows, she is not entitled to maintenance. Supreme Court judgment, she is not entitled to maintenance. If so much she has rejected.
To survive, then only you will take care.
My lord.
She has to survive.
Yes, that I don't dispute. But
pay something.
What was the earlier order that I am giving? But application after another she will file and I will go on paying. But I will not.
See who is appearing for. Who is the counsel?
Mr. Tripathi. Khudanand Tripathi and associates.
Just see, find him out. I will send it to mediation if you can find him out.
Your lordship kindly call it day after tomorrow.
Please sit next week.
Or Monday. Right.
Yes.
43.
Please, your lordship. Present CRMC has been preferred against the order passed by the Annexure 4, your lordship, in the criminal revision. The gist fact of the matter is that there exists a pipe exhausting the sanitary area of the respondent, your lordship, towards the residential house of the present petitioner, your lordship. In the show cause preferred before the court of first instance, the present opposite party has clearly admitted to the fact that he can shift the said pipe 4 or 5 feet away from the present position in order to prevent the nuisance that is emanating because of the smell, your lordship. But both the learned courts have failed to take into account that fact. Rather, in the criminal revision, your lordship, the learned appellate court has ordered to increase the height of the pipe to 4 to 5 feet, which has now resulted in the said pipe emanating the said nuisance near the bedroom of the petitioner, your lordship. Because the house.
You want removal, the court says that increase the height.
Increase that.
That's the problem.
Even if it is not removed, even if it is shifted from the present position to 4 or 5 feet away from the present position,
whether it is feasible or not, how will I know?
It is feasible as per the admission made by the opposite party himself.
Show me.
In the show cause at page 16, your lordship, para 10.
16, yes.
At para 10, your lordship. That for the benefit of the petitioner, the OPs are agreed to like the gas pipe at least 4 to 5 feet for which the inconvenience can be solved.
Whose affidavit is this?
It is the respondent, your lordship.
Yes, what do you say?
That is, your lordship, I am agree to hide the pipe.
No, you yourself have said that for 4 to 550 you can.
4 to 5 feet height, your lordship.
No, height. Where is height? You don't say that.
Yes, your lordship.
The benefit of petitioner, the opposite parties agreed to like.
Sir, height like wrongly.
Agree to like is height, he says.
Height, my lord.
Typography error. Agree to raise the height. Gas pipe 4 to 5 feet. See, the problem is if you raise it, it directly creating problem.
Your lordship,
I
am residing there since 99.
What is the problem? Why can't you change?
If change more problem, I will face problem. In a small area.
Show me the map. Photograph, anything.
There is no map attached, your lordship.
So these are the cases I can't decide on the basis of this.
On the basis of record.
Show me the photographs and all. If possible, we will do it.
further time may be granted, your lordship, I'll produce this.
File. Get the photograph and show me
Yes, your lordship.
whether it is feasible or not. If it is feasible, then he has to remove it. Is it
Yes.
not feasible?
No.
No, it is ego issue.
Then that will be very closer to my residential house.
So you want to,
No,
you want
I am
to be
residing there
but
since
you can create problem for others.
I am since 1999. He is in 2020. He has constructed his house. I am since 99.
Let us see the photographs. You get the photograph. This is the scavenger line.
Not the scavenger line, your lordship, your septic tank. Septic tank, the exhaust of septic tank, it is besides the plot of the petitioner, just beside. So if it is gas, your lordship, if it is bent and made to go further 4 to 5 feet.
But what is the remedy if there is no remedy available to him?
Oh, that would be clear, your lordship, once I produce the photograph.
Get the photograph.
Yes, sir.
Simply adjourn it. Yes.
4 months away.
Mediation report is flag P.
Mediation report is flag?
Flag P. P for Puri. Only 294 is the non-compoundable offense, and both are the relations. Both sides are related.
On the other side.
Yesterday, yes, my
I'm
friend has
opposite
come.
by note 2.
My friend has come.
Matter is subsided, my lord. One thing, my lord. Dispute arising or civil suit. Technically, direction to the petitioner, we do the counter case before the court.
Yes, we undertake to.
Whatever you have agreed, that will be done.
Yes, yes.
Yes.
We undertake to not to proceed now.
Both of you undertake to comply the
Mediation.
Right.
settlement terms, which
Fine.
has been
Yes, yes.
right on. The matter was it petitioner and the opposite party number 2 are the brothers. The dispute is arising out of misunderstanding regarding the distribution of assets of ancestral asset. Since the parties are real brothers, the matter was referred to High Court Mediation Center by the order dated 2/9/2024. The parties have entered into a settlement through the mediation process, and the High Court Mediation Center, its report dated 16/12/2024, has submitted the terms of settlement terms. The mediation report reads addendum. The counsel appearing for both the parties have conjointly submitted that both the parties are bound by the settlement terms arrived at during the mediation process. And the settlement terms is form part of the part and parcel of the present order, and petitioner and opposite party are the petitioner and opposite party through their counsel have undertaken to comply the terms of settlement without fail. In view of the successful mediation and the agreement between the parties to withdraw the cases initiated by each other, initiated by them against each other, the present petition deserves to be allowed. Accordingly, the so is cost. What else I I just quashed.
So also cooperate that for quashing the
And,
other case.
uh,
Case
need-
and counter.
need- needless
Case
to
and counter
say
is my
that,
lord.
Only 294 is the non-compound.
Needless to say that the parties shall cooperate for termination of all the proceeding initiated by them against each other. Yes.
But present case is quashed.
Present question. FIR number 414.
Well, counter case may be direction to the petitioner. We don't know.
I have written.
My lord has
My-
taken it. My lord has directed.
Yes, I have
My
written.
lord.
46.
It is at the instance of opposite party. The fire was very the petitioner. Allegation. After you would have put it refer to mediation. In any case, in view of the settlement, at the instance of High Court Mediation Center, subjecting the petitioner to yes. Yes.
What is?
Yes, but while Laurent wants
Yeah,
that she has not been served with a copy. Let
Appearing for the informant, there is 3 CRLMC filed, only 1 CRLMC notice served to me, and other 2 are not served on me.
Okay. Then please give
but I'll serve the copy by tomorrow.
after 1 week. After 1 week.
Now she has appeared, so don't notice.
Notice is not required. You just
Full copy, sir.
the counsel for the petitioner undertakes to supply the copy of the petition to the counsel for the opposite party. Leaves the matter on file. Yes.
Sir,
In this case, I am for the opposite one of 2 mail. Informant in this case, mail. Let's see, next week and date.
What happened? You want to file reply?
Mail.
You want to file reply?
I'll take instruction mail regarding instruction. Let's see next week any day.
Opposite party number 2 submits that he has not obtained instruction from his client. Therefore, he seeks an amendment. Leaves the matter after 2 weeks. Yes.
48.
Maybe sent to mediation.
What happened?
This dispute between the husband and wife.
You are appealing.
Appearing for the respondent wife minutes.
What do you want?
The-
Let them avail a chance. They have not seen each other for long.
What do you want?
I'm ready for mediation, no problem at all.
The dispute is rising out of a matrimonial discord. The petitioner is the husband of the opposite party number 2. Both the petitioner and opposite party number 2 are represented by their respective counsel and conjointly submits that the matter is likely to be settled out of court and request submits that the matter may be referred to mediation center. Regard being had to the submission made by the counsels for the party, the matter is referred to mediation center. And, you tell me the date.
But take a Lombard date. The husband stays at Delhi.
Lombard date Lombard date.
If he wants,
Is there any chance of reunion or
Separation only.
separation?
Since 2020, the wife is residing here in Cuttack. She is a homeopathy doctor. The husband is also a homeopathy doctor in Delhi. And there
It's a
is
matter
no
of
chance.
money now.
Matter of
Daily
money.
No, I have tried restoration of conjugal.
After filing of the divorce petition by the wife.
No.
Yes.
It has come.
It has been
come
transferred
to-
from.
Yes, the
transferred
fact
from-
remains that you are not going to be
Yes, Your
reunion.
Lordship. Yes, Your Lordship.
Or
After
date will
several,
be fixed and,
pardon to make a mention. My lord, on the last occasion.
February 2nd week.
On the last occasion, Your Lordship directed, granted a liberty to seek adjournment to the petitioner.
Further proceeding stage. Further
Stayed.
proceeding- Yes. Because see, in these kind of cases, if I will not say, it will be precipitate, unnecessary. Then the chance of settlement is
Infructuous. This petition will become infructuous.
once it is sent to mediation, at least the proceeding has to be stayed.
Till February,
February, till next date of hearing.
deeply apprised.
I'm ready and willing to take them.
Every time he is saying that.
He doesn't want to go. What?
My two children.
After 14 years of marriage, after having two children.
My lord, I may be pardoned. Their two children are there. The husband is not taking care of them. For the last 3 years, he did not take care of them. After seeking maintenance for the children only, not for the wife. Finally, after finding
Whatever, now it is a matter of money now.
Yes.
Matter of
If she is not willing, it is a
matter of money. You don't.
Regular maintenance, I am paying back.
After filing of execution only. Yes,
Whatever.
sir.
Now,
Sir, please.
I have paid.
now you decide how much you want for alimony and put it across. And
I will take instruction, my
Let
lord.
them sit, let them sit for consultation.
if it doesn't happen, then we will try and do.
Your lordship, deeply obliged.
49.
In 49, I am appearing for the petitioner. This is that 9 crore check amount. The lordship had asked me to inquire from my client as to what could be the modalities of settlement. The client is willing to make payment in 8 installments, equal monthly installments, starting from March 1st, my lord. Is it acceptable to Mr. Rath? So it comes to 1 crore 12,50,000 per month, my lord. 8 months.
What is the check amount?
9 crores.
9 crores.
Lordship had suggested 4 installment, but it's not practical, man. It's difficult on her part to arrange the entire fund. So she doesn't want to take any risk further. So without going into the merits, because I'm not arguing the matter on merits now. If my learned friend agrees to this proposal, we can settle it. Otherwise, we have
Proposal is 8 installment you want.
8 installments starting from 1st of March.
Monthly installment.
Can it come tomorrow? But I can ask them if they are agreeable.
Yes, let him seek instruction.
Only tomorrow.
Starting from March.
Starting from March.
Let me call them. If they are agreeable.
But to demonstrate your bona fide, you must deposit the first installments. Then only I can put it up.
That I'll work out, my lord. That I'll work out.
Okay. Tomorrow. Day after tomorrow. Day after.
Sir, day after 9 तारीख तो ମୁଁ ନାହିଁ sir 10 ତାରିଖ ଟା ମୁଁ ନାହିଁ 9 ତାରିଖ ଅଛି ନହେଲେ
କାଲି ତ 9 ଆଜି ତ 8 ତାରିଖ ନା
it can be passed over. I'll take instruction.
Okay.
After lunch. I am coming back.
Pass over.
50.
Conciliation failed, my lord. Matter has to be heard.
Conciliation failed. The matter was referred to mediation, High Court Mediation Center. However, the out of court, the mediation report indicates that the mediation has been unsuccessful. Matter is to be heard on merits. Release the matter and so on. So entry mode to continue. Entry mode to continue. He'll give a date after. Just see. Yes.
51.
Bring for an action.
My lord, I am appearing for opinion.
He is not able to speak. Because Mrs. Sao is not able to speak.
My lord, I am appearing for opinion number 2. That in this case, the petitioner filed an application under section 482 CRPC with a prayer to pass the criminal proceeding initiated against the petitioner in connection with the Balesur Town PS case number 1.
That's right, but he is asking for an adjournment because he can't speak.
But I have submitted the objection to it, dated 8 November 2024.
Give the copy to.
I received the counter, my lord. I have already received the counter.
Okay, he has received it. Yes. Okay. Please sit. Huh? Yes. Next.
52.
At the passing of cognizance, the offence under section 294/506/34 IPC, notice was issued. Last order, lordship can learn it is sufficient, but he is not interested to participate. That order is there. So allegations of in the case and counter case, my mother was misbehaved by the informant and others, for which I have lost at the time of occurrence. I was at my service place. I went and lost the FIR. Thereafter, this counter FIR has been lost by the informant, and the allegations, lordship can learn space 13. The only ଅଶ୍ଳୀଳ ଭାଷାରେ ଗାଳି ଗୁଲଜ କରିବା ସହିତ ଆମମାନଙ୍କୁ ମାରିବା ଏବଂ ଥାନାରେ ପୁରେଇବା ପାଇଁ ଧମକ ଦେଇଛନ୍ତି। ଦିସ୍ ଇଜ ଦ ଆଲିଗେସନ। କଣ ଅଶ୍ଳୀଳ ଭାଷା କହିଲେ that is not there so far to attack the 294 and 506 LRC nothing is there. Minor offense and I have met one accidental LRC and thereafter for better treatment when I applied for a passport LRC, I came to know that such case is pending against me LRC. That I am also annexed that document LRC.
Service is completed, huh?
Yes, that is that through ତାଙ୍କ ସହିତ ବି ଏ କଥା ହେଇଛନ୍ତି ଯେ out of court LRC ଯେ ସମାଧାନ
Through IIC once again, sir. Through IIC, through IIC, sir. Entry mode to continue. Get him. This is the allegations are very minor, very minor. It can be quite unnecessary. IIC, tell IIC to bring him here. IIC, opposite party number 2, service. Yes. Entry mode to continue. Yes.
For date LRC में fix my predicament LRC I went better treatment ପାଇଁ ବାହାରକୁ ଯିବା ପାଇଁ passport apply କରିଛି କିନ୍ତୁ ସେଇଟା ହେଇପାରୁନି due to pendency of that criminal proceeding.
See, if you go by merit, I can't quash cognizance order because there are allegations. But since the allegations are minor in nature, I want to intervene and let it come.
Yes, but
I can't quash it because cognizance order can't be quashed. There are allegations. Very specific allegations are made against you. If you want on merit, then I can dispose it up. I am trying that
Yes, sir.
once he comes and I will record this thing and quash it. Otherwise, on merit, if you venture, then you will not get succeeded. That's the problem.
Date LRC.
That's the problem.
55. Pardon. Pardon. 53.
53, what happened? Who has mentioned?
I am appearing for the opposite party. If she has taken time, I only pray the petitioner have filed 2 cases, challenging 2 orders. One from domestic violence, another for quashing of affair. I pray, madam, those matters can be taken out together. If she has taken time.
Give the number and yes, 54.
54, madam. My lawyer senior
Yes.
taken adjournment.
Yes.
I pray, madam, the entry model may continue.
Entry model will continue.
Obviously.
55.
ଏଥିରେ present development is ଲୋକପାଳଙ୍କ report ହେଲା 29/4/22 ରେ on the basis of the Lokpal report 29/4/2022 the vigilance case was initiated and cognizance was taken on 11/7/22 but the report of the Honorable Lokayukta was quashed by this Honorable Court, page 130. All proceedings emanating therefore against the present petitioner. 130. এইটাକୁ ନେଇ ଦେଖିଲୁ ଭାଇର present development is the quashing order of this Honorable Court will place before the vigilance judge. So they are saying that you file a petition, they accordingly will drop the proceeding. Because after the disposal of the petition, whereunder the report of the Lokpal was quashed. So consequently, for the emanating proceedings, also liable to be quashed. And I put a petition to file Koriju, the Lordship may dispose of the vigilance judge.
So me.
Prayer.
Application. Show me the application. I'll just simply say that he moved an application before vigilance making same prayer. Let it be decided.
Sure decide karibe.
Where is that application?
My lord, nahi ame application ta set file korchu, local lawyer file korchu.
Show me that application.
My lord, mo pakhare nahi, local lawyer file korchu. Say 133.
Land Council for the petitioner submits that the present case is emanating from an order passed by the Lokpal dated
on 29/4/22.
On 29/4/22. The said order of the Lokpal has already been quashed by this court by judgment dated 19/4/2024 in WPC number 21206/2022. Therefore, the
more it hଉଛି 21206.
21206. Yes,
Huh.
that's what I'm saying.
Yes,
21206. Therefore, in the council, therefore, the petitioner has moved an application before the trial court for dropping the entire proceeding on the ground that the proceeding has been emanating from an order opposed Learned Lokpal, which has already been set aside by the division bench of this court. Division bench of this court. The application is pending for consideration. Hence, the petitioner seeks to withdraw this petition with a petition to press his prayer before the court below in that application. Hence, the petition is disposed of. Yes.
56 seek for an adjournment, your lordship. Much of
7.
Mark what's the unless it is urgent. Yes.
Please. This notice has gone to the complainant opposite party. He is appearing. The file
Are you appearing, sir?
Yes.
He's appearing.
His file and counter affidavit. Let me kindly say that at page below annexure 2. The entire transaction has been made at Borgad, Sohela. Complaint petition filed at Bhubaneswar. And the court below has no power to take cognizance because cause of action arose at that Sohela particular district of Borgad, my lord. And the petition is working as a PO. There is no allegation against the PO, my lord. The government servant sanctioned without sanction, court has taken cognizance. There are two faults of my lord. The court has no jurisdiction to enter in this application for complaint case.
Court doesn't have the territorial jurisdiction. Second sanction is not there.
Yes.
That's what you are saying. Yes. In the counter, what does he say?
My respectful submission, my lord. All transaction has been made before the Bhubaneswar. The head office of the company is Bhubaneswar. And the PO is the only responsible person who has to take money 70,000 before allotment of the work, my lord. After issuing the work has already completed. The amount of 3,06,000 has been transferred to the Sarpanch on behalf of the PO, and he has grabbed the entire money. So the company has not taken a single pie. Rather, he has spent 70,000 for the PC. My lord, against that, I have filed a cognizance case before the JMFC Bhubaneswar, and Bhubaneswar court has a right to take cognizance. And someone has been issued. The video has already appeared and a release on bail. Now, NBW has been issued against the PO. PO is the only responsible person who has grabbed the money and he has taken the money. And after complete the work, the entire transaction has been made before Bhubaneswar. And the company, how can run after payment of the 4 lakhs and not pay a single pie? And the PO is the only responsible person.
What about the sanction part? What he says?
Lordships?
Sanction.
Sanction before Borgad, my lord.
No. He says official. He was doing his official duty.
Yes.
Therefore, he is protected. The immunity of sanction is there.
Yes, my lord.
In Bhubaneswar, my lord.
That is a different thing. Territorial jurisdiction, I am not asking.
Yes.
What about the sanction? The objection, he says that he can't be prosecuted. Cognizance or order is bad in the absence of proper sanction by the competent authority.
That is the court has already taken cognizance, my lord.
That is what he is challenging on the ground of sanction.
One of them accused person has a release on bail.
I am asking something else. You are released on bail.
I'll take instruction.
First, he has two objections.
Yes.
One is the court doesn't have the territorial jurisdiction because none of the part of the offense has taken place in Bhubaneswar. First objection.
Yes.
Second is objection. He is working as PO, progressive assistant. Panchayat executive.
He is the main culprit, sir.
So the act complained of is in his official duty.
Yes.
Therefore, to prosecute him and take cognizance, proper sanction is required.
Yes.
Under 197
Yes.
CRPC. To that, what is your answer?
I'm taking instruction, my lord.
In the reply, I don't think you have said anything about that. For the lack of sanction, the cognizance order will go.
My lord, even if the cognizance order has been passed, I have no objection. But my lord, my admissible dues has been taken in the company, my lord. How can run without money? I have
What is the amount?
And 3,06,000. that has been stopped and already 70,000 take PC.
Why don't you pay something
Yes.
and finish it up? See, you are working
Laborers has been taken money.
unnecessary. Why are you creating problems?
He has given them.
And technically, take a view, you go to that court, that this court. You spend more money in defending yourself. Pay him and finish it up. I'll quash it here.
Yes, I have no problem.
70,000 he has given to Sarpanch, not to the petitioner.
Forget about you ask Sarpanch or whoever it is, pay. This money is not a big money. I didn't mean a huge money, I can understand. Small amount, pay and finish it up. I'll quash it here. He's saying that I'm interested in my money. Pay him. He may accept little lesser than what he's claiming.
I have no objection against it.
Because he's also spending money in the litigation.
How can company has been
How much?
3,06,000 and 70,000 PC.
70,000 is gone to Sarpanch account, not to
The total claim you tell me.
3,06,000.
3,06,000.
अच्छा PC ଟା ଆମର ଯାଉଛି ଖାଇ ଦିଅନ୍ତୁ କିଛି ଅସୁବିଧା ନାହିଁ ଆମେ ଏତେ
ଆମେ ତ ଖାଇନୁ ଖାଇଲେ କରେକ୍ସନ କେମିତି ହବ
ଅଛି ମୁଁ ଦେଇଛି ତା ଦେହରେ
ଆପଣ ନିଜ ଦେଖନ୍ତୁ କମ୍ପ୍ଲେନ ଆପଣ କଣ ଲେଖିଛନ୍ତି
I'm putting it tomorrow. Come with the money. I'll quash it.
tomorrow
You come with the instruction. How much you will pay? I'll record it and finish it up. I'll quash it. Otherwise, you will be in trouble. I tell you. You will spend more money on defending yourself. And you are working a government employee. Government employee. I'll quash it at least. Pay. He's interested in his money. If not 3 lakhs, pay something. I will not express my.
next week sir ଆସିବ
How much you will be happy?
ନା ନା ଯେତିକି ମୋର ଖର୍ଚ୍ଚ ହେଇଛି ସେତିକି ଆଉ ମୁଁ
ନାଇଁ ଟିକେ କମ କରନ୍ତୁ ନା
ନାଇଁ ତା ଦେହରେ ଅଲରେଡି ସବମିଟ ହେଇଛି ବିଲ୍ ସବମିଟ ହେଇଛି ସେତିକି ଆମାଉଣ୍ଟ ସାର୍ ଏଟା ସୋଲାର ଯୋଉ ଲାଗୁଛି ସେ ସୋଲାର ପ୍ୟାନେଲ ଟା
ଆପଣ କିଏ କହୁଥିଲେ ଖୁସି ଦେବା ପାଇଁ
ପିସି ଟା ନ ଦିଅନ୍ତୁ ପିସି ନ ଦିଅନ୍ତୁ ମୁଁ ଯେତିକି କାମ କରିଛି ସେତିକିଟା ଦିଅନ୍ତୁ
କିଏ କହୁଥିଲେ ଆପଣ
Shall I send it to mediation?
decide here.
Decide here means you have to pay it, otherwise you have to take
3,06,000 ଯେତିକି କାମ କରିଛି
70 ଆପଣ ଦେଇଛନ୍ତି
ସେଟା ନା ନା
I'll suggest you one.
Sir.
You please sit with him and just speak with your client and I'm putting it day after tomorrow, you tell me.
Monday at least first.
Monday sir Monday
Huh? 15th, huh?
हाँ
You tell me, you decide yourself.
Yes, sir.
And advise your client, pay some money or the installment, whatever, and finish it.
Oblige.
Okay.
15th
Don't get into technicality. I'll take view and
There is no allegation against this PO, but he has no road to blame that. Only he has been.
don't be sure about judicial proceeding. I may take a different view also.
The sanction is not there,
There are many ways to dismiss a petition.
but there is some lacuna in my source.
You have taken money, you pay it.
I have not taken money.
Whatever
Let
you
him say what I have taken.
sit with him, sit with him and decide.
ଦେଖନ୍ତୁ କାଗଜ ଦେଖନ୍ତୁ ତା ରିସିଭ୍ କରିଛି କି ନାହିଁ
15th, you tell.
Then entry model value that.
Entry model will continue till 15th and you tell me. Yes. Go to the password. 58. 58 password.
59.
South of Symmetry. Hearing that. Yes,
58 Malasip.
58.
58 Malasip.
Yes.
That the petitioner challenged the cognizance order dated 18/5/2023 Malasip. That with certain 4 grounds Malasip. That earlier I am stated that with 4 grounds Malasip. The petitioner challenged the cognizance order Malasip. That firstly that the presented check before the law and trial court is a stolen one. Then secondly that Malasip the file before the law and trial court is not in time and not and bear by the limitation, and without filing the appropriate application to for the condition of delay, that malus cognizance was taken. That is my second plea malus. And malus, and there is no legal debt liability is made out in this case.
All these things you can take in the trial.
Yes, malus. But I no malus. But that's why and malus, I am so fortunate that
I have called him. You pay the money and finish it up. That's all.
malus. That
What is the check amount?
25 lakhs malus.
You give in installment.
Malus.
Give on installment and he will be happy.
Malasip, that check was cancelled by me in the year of 2021.
Then face it.
And Malasip, and the presented check by the complaint is total 23 Malasip. And here Malasip, after I am filing the FIR, that police recover
all these things you have to prove on record.
Yes, Malasip.
By bringing adequate evidence.
Yes, Malasip. That Malasip, today I am so
my learned senior, where I'm starting my advocacy, is I'm standing beside him.
So he will increase the installment now.
And I am so nervous, I'm not prepared today. So I need some time, my lord.
Can you narrate what happened in this case, my lord? He has already filed an application under section 258 of CRPC, my lord. The same plea, my lord, before the trial court, my lord. He filed this application.
And I'll direct the trial court to decide that
No,
application.
that is not maintainability.
Therefore, I'm giving a direction. Let it be decided.
Yes, my lord. The petition has been filed.
As to that submission, my lord, I may be allowed to submit the one decision of
what I'll do is I'll direct the trial court to decide your application which you have moved.
The trial
And
have
at the
no
same
power.
time, I'll ask the trial court to explore the possibility of a settlement before proceeding.
My lord, that trial court have no power in deciding for 258 in this. The application, my lord.
You have filed the application.
But you have filed it.
My lord, but my lord, as per the decision, I'm maybe requested to present before this honorable court that 482 applications is separate things. My lord, it is decided on merit.
That who stops.
But today, my lord, I'm not.
But on merit, you don't have
it is my prayer, lordship, to give some time to so that will be easy and make an argument.
All right, simply adjourn. Simply
My lord.
after 1 week. Prepare and come and sit with him if you can work it out and
No, my lord, senior is there.
work it out and settle. Yes.
59. May I please ask?
Yes.
Yes, my lord. 59 minutes, maybe taken some other day, my lord.
What happened, my lord? Actually, my lord.
No, in fact, the abator wife, who is now the widow,
My lord.
my lord, this is the second revision against an orders rejecting her second application for discharge, my lords. In view of lordship's leave granted to her, my lord, that you move the application. My lord. Once this application rejected, see that the dependency, the main accused, my lord, died, my lord, husband died, my lords. And
Only 109, my lord.
she approached this.
109 cannot run, my lord. At the framing of child, husband expired, my lord. 109, he came to before this honorable court, my lord. You are also directed to re-hearing.
Reconsider. And to file a fresh application.
But the court below, my lord, not, my lord, even taken to consideration the aspect.
Detail, in order reveals detailed judgments. But in this case, 4 judgments comes to play. That has to be placed by both the Mr. Ragada. I know, my lord, is very persuasive in that.
Abatement in the absence of a main principal accused.
And my lord, 4 judgments. Arthi Sao case, Nalini Mudali, Nirmal, Jayalalitha.
You prepare.
That is there, my lord. In another decision of your lordship, my lord, is one of the case, my lord. 107, not my lord, this 107, 109, my lord. That has not been, my lord. Ingredients have not been fulfilled.
No, whether this
both big points, my lord.
petitioner, no, this petitioner
My lord.
has put forth his own defense.
Huh? Yes, he is running a business.
Then
No.
that-
Para 4.
That is there, my lord. But
was engaged in
involved in this case, my lord. First point, my lord. In the absence of a husband, my lord, principal accused.
That's the first point, yes.
109 run on
That is what we will have to
But there
deliberate
are
upon. Deliberate upon.
so many judgment of the apex court and this honorable court.
Then he is asking.
And second, my lord, 1
Wait.
15 tarikh.
Huh?
हाँ बस 17 तारीख 16
बहुत difficult.
16 छोटा कैसे 10 मिनट लगे
ସବୁ ଛୋଟ କରି
note करें description
and see citing for them.
In fact, he has become more persuasive on that side. He has become more persuasive on that side, bro.
Since you are
It seems.
Yes, bro. He has come up in a flying color. He has come up in a flying color in the second
when I am just
Once you appear in a matter, it can't be a small matter.
Yeah.
As simple as that.
Agreed, bro. Agreed.
So let it be just adjust it.
8
Just he adjust it.
17 ଭିତରେ ଆସିଲେ ବେଟର હતા 77 ଭିତରେ ଆସିଲେ ବେଟର
Let's, if at the end, my senior is on his way from court number 6, my lord.
Next item.
7
419 and 467 and 468 and IPC. They dispute when 2 brothers, my lord.
Yes.
So that I am in bail, my lord. I also in the answer 2, page 16, I am in bail, but I want to dispose of to amicably settle my lord, so that I file the.
You want settlement?
Yes, ma'am.
Do it. Do it. I'll just simply adjourn. Bring him. Bring
Yes,
them.
ma'am. So I only notice to my brother who is Sarat Jana.
What are the offenses?
The offense is 419 and 467 and 468.
No way.
Using his name as
Hmm?
using his name and creating false Aadhaar card and everything. I used that in Gujarat.
His brother.
His brother.
Okay. They are brothers.
Then they form under.
They have to come.
Yes, yes.
Simply after 1 week. Yes.
Item 10. 10 and 34.
But 10 and 34, I have appeared as opposite party in item number 10. And 34, I am the petitioner. But I have filed my wakalatnama. In fact, parties have settled the dispute.
No, I just wanted to know what is the injury.
Yes, injury, your lordship will kindly.
Where are the parties? Parties are there?
No, parties, your lordship, if your lordship permit, I can call them any day suiting to my lord's convenience. Their joint affidavit, they have already prepared. We can file it.
Show me the injury.
Yes. My lord, in the, while granting bail in the trial court.
Show me.
Yes. I have marked it.
Simply injury.
My lord, on the knee.
Instruction as a result, suspend severe bleeding injury.
Deep cut injury.
No,
the right knee.
Right knee.
Page 24, 34.
And the head.
Page 24 of the 34. I don't know.
You have to implead these
Yes,
injured.
I have impleaded them. Impleaded. Yes, injured has been impleaded.
They also injured and filed in item 10. First paper, then the counter paper. Both are moved.
My lord, the
knee injury is grievous.
Yes.
Head injury is simple.
Simple.
The injury code is not there.
Now this is the finding.
While granting bail, the court below has come to that finding.
16, 17. You
But
bring that.
can it be on 15th? Because another compromise your lordship has posted to 15th.
15. You bring that.
My lord, your lordship may direct the registry to indicate my name in item 10 and 34.
Yes, CRLMC 4880. You listed along with
Yes, item 10 and 34 same.
4757 of
Both the matters.
Both the matter, case and counter.
Both the matters.
Case and counter case, man.
Who injured the file?
Yes.
38. Grateful, ma'am.
Yes. 38.
May I please, your lordship, on behalf of Ms. Mahapatra, my lord, due to some difficulties, he is not present. Kindly praying for an adjournment. Already consent taken from the opposite side.
On request, adjourn. Yes.
41, yeah. Today I have filed an affidavit of the copy.
There is interim order.
Entry order.
41 I have filed an affidavit and solved the copy, and Mr. Das also is not available today. So I request kindly fix it on 15 or 16.
What do you?
15 or 16?
15th may not be possible.
16.
16th may not be possible.
Then 14th.
No, this next week is not possible. It's completely flooded.
Tomorrow can.
no.
21. No. Date.
He will give a date.
Date.
Adjust will give it. Yes.
59.
Yes.
I am there for the petitioner, my lord, in item. Is it 49 item?
Yes.
My lord, I'm for the opposite party, my lord. My lord, I pray for one passover. Mr. Author is on his leg, my lord.
Passover last item. Have you got the instruction?
My lord, we have got the instruction.
What instruction?
My lord, he is ready to that.
Then I'll put it day after tomorrow.
My lord.
Day after tomorrow. They have agreed. And you circulate a draft.
Okay, my lord.
What is your proposition? They are agreeing and they'll you circulate tomorrow itself.
Okay.
The settlement terms, and Mr. Rotho will revert it day after.
Right. I'll do that.
the parties have preliminarily agreed to settle the dispute. Mr. Acharya would circulate a draft settlement terms by tomorrow to the learned counsel for the petitioner, Mr. P.K. Ratho.
The opposite party, I'm for the petitioner.
Opposite party, P.K. Ratho, lease the matter on day after tomorrow, 10th. 10. You circulate?
I'll do that. I just have one grievance, my lord. On the last occasion on 3rd, I mean, your lordship categorically said that the interim order will continue, but unfortunately, I don't know what went
The interim order will continue, it's all right.
No, what I'm trying to say, the steno never took that order, my lord. I mean, he never typed that. This is very unfortunate. I mean, how the stenos can act like this if they are not obeying the court.
See, this happens, because of the pressure.
Kindly say today, let the interim order continue. So the
interim order to continue, but day after tomorrow, either this way or that way will decide. Yes.
I'll do that. Yes.
Want to continue till next day.
Item 2.
Yes, item 2. No, adjourn कर दो. Okay.